How long does it take to get my personal injury case resolved in Tennessee? Hi, I'm John Griffith. I'm a personal injury trial lawyer practicing law in the state of Tennessee. Every time I have a case and we can't resolve it voluntarily with the insurance company, my clients ask me the same question. How long is this process going to take? Well, the truthful answer is, it just depends. Everything in the litigation process is governed by the rules of civil procedure in the state of Tennessee. There are certain timelines within these rules that govern how long it takes to resolve certain steps of litigation. Let me give you some examples. After a lawsuit is filed, that simply begins the process. Then the person or persons that are being sued have to be served with the lawsuit. After a person is served, they have 30 days to file an answer. Once the answer is filed, usually discovery begins. Many times I'll send a set of questions called interrogatories to the party for which we are making claims against. In return, their attorneys will also send interrogatory questions for you to answer. The next step in litigation generally involves taking the depositions of the parties. What is a deposition? A deposition is simply a statement under oath given to your adversaries. This statement under oath is transcribed by a court reporter and can be used in trial against you if you give contrary answers at trial. After the depositions of the parties have taken place, usually most of the time, although there are exceptions, you'll move to deposing witnesses and your medical providers. The treating doctor for which you've treated to care for your injuries will also need to be deposed to establish the medical perspective from all of your harms and losses that you've sustained as a result of this incident. Most counties now require both parties to attend a mediation prior to giving a trial date in your case. After the mediation is attempted, usually we can obtain a trial date fairly quickly after that time. The more lawyers, the more parties that you have, the longer it takes. Why is that? If you've got 5 parties on the other side and 5 defendants and numerous witnesses, just to schedule one deposition requires your calendar, my calendar, 5 other attorneys, 5 other people or entities that we've got to depose, and sometimes just setting a deposition can be 3 to 6 months out. Most of the time, it's only 2 parties, you and the person that caused your harms and losses. In that event, it's much easier and quicker to schedule depositions, doctor's proof, and get it set for trial. Generally, the overall time period it takes for litigation to be resolved is between 9 months and a year to a year and a half. The insurance company will make you a lowball offer early in the litigation. So if you want to settle your case quickly, it can be done very quickly. But typically, the best money comes after we've proven our case and the defense can no longer try to poke as many holes in what your proof might be. When we know what the proof is, it's harder for them to argue and the noose tightens. If you have questions about your case, call me. I'm here to help. I can be reached at 615-807-7900 or email me at john@griffithinjurylaw.com.